And now we are on. And today we have a set of legal questions. This is a webinar for questions for Creative Commons Copyright and Licensing Counsel, who is Kat Walsh. She's the Copyright and Licensing Counsel at Creative Commons, and she has been involved for a long time, both with Creative Commons, but also with the free and open culture movements. And she has played roles in the board of Wikimedia Foundation, the Free Software Foundation, and she has worked in library policy, technology startups, and online community management. And so thanks, Kat, for being here. And the idea is that this is an open conversation for you, for those of you that have questions. And once your questions run out, Kat will go through the document that we've invited you to fill in for answering those questions. So with that being said, thanks again, Kat, for being here, and for all of you who are here, and let's go ahead and get started.
Great, and thank you for co-hosting, and it's lovely to be here. As mentioned, I'm the Copyright and Licensing Counsel at Creative Commons. I'm going to give the obligatory lawyer disclaimer, which is to say that I am a lawyer. I am not your lawyer, so I can't give you legal advice about your specific situation. What I can do in this situation is if you have general questions about copyright or you want to give example things, I can talk about the legal principles involved and a lot of the things you might consider. But some of the things you bring up, I might have to tell you that here are some of the things you might consider, but you're going to have to go back to your own institutional counsel or any other lawyer that you have available. But I'll try and be as helpful as I can. I know there are a bunch of good questions in the document, and I'm not sure if everybody who asked those questions is here today. So I want to prioritize the questions from people who are actually here. So I know you might have written them in the document already, but if you have a question that you'd like to ask, go ahead and jump in the chat, or you can raise your hand if it gets chaotic, but I think we're a small enough group that people can just jump in. And if people have no questions, I will just start reading from the documents. Right. All right. I'm going to start from one from the document, and then here's one that's kind of straightforward. Can a course host a public film showing that has a panel discussion portion before or after the film? It's on campus and admission is not charged. University legal counsel said no, unless the students who had no funding source paid licensing fees, even though the library had a version with public performance rights. So that one, in general, if you're doing a performance of a copyrighted work that's open to the public, in general, you need licensing fees, even if it's on an educational institution, even if it's mostly for the education. If it is open to the public, that's considered a public performance that needs special licensing. If it is only being shown within your course, if it's only open to students who are registered for the course, that's something you usually don't need a separate licensing fee for. But if it is going to be open to the public, that's usually something. I'm not 100% sure what the question asker is saying about the library having a version with public performance rights. If there is some agreement that says that it is available for public showing, that you can show it to the public without additional license fees, that should be sufficient. But you'd need to look at that. You'd need to look at that agreement with your counsel to determine whether you do in fact have the right to show that to the public without licensing fees.
I think that someone that is here in the room added the question number 11. So if you want to go to that one.
Yeah. So the non-derivative licenses say you can't share adaptations or derivatives publicly. What falls under publicly? That would be pretty much anything that isn't for your personal use, or it can be within an organization, or within your family, or within or within an instant, like within a like tripping all over myself. It can be for your personal use or within an organization or company is often not considered publicly, but if you're distributing to like the public, someone who you would generally have to get a license to make a copy to share with them. If you would have to get a license in general to make a copy to share with them, you would not be able to make a derivative and share it with them if you've got material under a non-derivatives licenses. So for example, you could make an adaptation and just like enjoy it for yourself, post it up on your own bedroom wall, but you couldn't, for example, post it on your blog or post it on the website or share it on social media.
Can I ask a follow-up question on that? This comes up often with so I can make an adaptation and share it on my wall. I could do that with fully copyrighted works, right? Like no one's going to come for me. So what's the difference between the ND being able to make adaptations and not share them versus just saying you can't make adaptations at all?
Yeah, so you just under copyright, you can't tell people they can't make adaptations at all. Like that's not something that copyright can control. Like if somebody is going to make an adaptation for their personal use, you can do it with an all rights reserved work. You can do it as with a non-derivatives work, because you're not distributing that copy. So when you're making your adaptation of your non-derivatives work, say you've got a song and you wanted to make a remix of it just for yourself to enjoy, or uh, if you're only making a copy and you will invite your friends to your house to listen to it, but you're not posting it anywhere, you're not depending on the permissions granted by the license to do that. You're just, you have a copyrighted work. You don't have a license to do what you're doing. You're making personal use of it, but you couldn't post it publicly for others to enjoy. Let's see. I see we've had a few other people join. Does anybody who's in the room right now have a question that they'd like to ask? Otherwise, I will go on to I like question number 6, which is I'd like to shorten the copyright protection length of my original content. How can I have it become public domain after, say, a period of 5 years? Is there a way to note the existing copyright time remaining, or do I need to make it public domain when the 5 years is up? The main problem in this is often marking your works in a way that is understandable to other people. Like it's hard enough to get people who are reusing the work to copy the correct attribution information, even when we try and make it as simple as possible. So something that is time-based and you'd have to know like how much time was remaining, or like, keep a copyright expiration date would be difficult. You can do it, but often if you're able to, it would be a lot easier to simply make it public domain when the 5 years is up. Just to distribute under whatever license you choose to distribute it under until that time happens, and maybe you can even publish a statement of intention saying like I intend to make this public domain in 2029 or whatever it is, but not to only do that, like when that time happens, to like change all the markings on your work as far as is possible, because otherwise a lot of that information just gets lost. It's very difficult to keep it. Oh, and I see in the chat that Anna Bittner says at one time you could buy DVDs either with or without public performance rights for a greatly different price. That's probably what they meant. And yeah, if you do have one of those and you did pay the additional price for public performance rights, you should be able to do that legally, but you'll need to make sure that that's what you have, and that's something that you'd have to like check your own records for. Right. Here's one. Can we use the CC BY 4.0 license for a database that includes databases shared under other licenses? And if so, how should we word it? Right. This one is a little bit of a confusing one, partly because rights in databases are a little bit like thin and confusing to begin with. And it depends on what jurisdiction you're in, what rights you have to begin with. In the US, for example, there's almost no protection for databases that are simply mechanical listings of facts. In the EU, they have the database directive, which does give some copyright-like protection to databases specifically. That's a little bit separate from copyright rights because it can apply to works that are not creative enough to be copyrightable. The CC licenses do apply to those. When you have database rights, you can apply a CC BY license to your database rights, and you can have a database that is a collection of other databases that may also have those rights. And this is an area of law that there has not been a whole lot of litigation around yet. So what happens around databases is often not very clear. But theoretically, you can have database rights that are very similar to copyright. And when you have one that includes databases shared under other licenses, basically you can't relicense somebody else's work. The license that you got something under is something that you have to pass on to any reusers. So say you have one that's you want to make a large database that includes work that's like by NC or by all rights reserved. You can put a CC BY license on the work that you have done to make the large compilation of all of these databases, but you would have to acknowledge that the underlying data sets were under all these separate licenses. It may be confusing to put a BY license on your database because there are all of these underlying databases where somebody might not actually be able to use them under the way that they think they could if they only saw CC BY. So you'd have to be just very clear about marking. And it's often not recommended to put a BY license on something where you know that the underlying works are much more restrictive in use, because a lot of people will be confused and not realize that there are several layers to licensing. It might be best just to acknowledge the licenses of the underlying data sets and then say, like, but if you have permission to use all these underlying data sets, you can use the larger compilation under CC BY. It's not easy to make this clear to reusers, but that's the main thing to do. Just make it very clear to reusers in whatever way that is sensible in your context as to like how they can reuse the works. Right. Yeah, and again, for the people who've come in, I'm just going down the documents of suggested questions, but if you're actually in the room, I'd like to get to your questions first. So please either like raise your hand or jump in the chat or just jump in. Otherwise, I'm going to keep going down the document. All right. So for a work such as an application where there are several elements protected by copyright, for example, photos, images, algorithms, and videos with different licenses but equivalent to CC licenses, is it possible to use CC BY 4.0? This is a very similar question to the last one about databases. And again, the principles involved are you can't relicense somebody else's work without their permission. You always have to pass on that original licensing information to the reuser. So for example, even if they have licenses that are very similar, that say that they used it under permission or, under some other kind of license, you do need to acknowledge the license to that original work unless they give you permission to relicense it. It is possible to use CC BY 4.0 on like the greater work that incorporates those works, but you'll need to acknowledge the original licensing status of the works that you're using. So say, for example, if you're using a song that's under another license, say it's like the free art license, or maybe it's even in the public domain, or you might want to say, application CC BY 4.0, like this media, this media, this media under different licenses. The main thing you want to do is always make it very clear to reusers what their obligations and rights are, and give appropriate credit to the creators. So often this is just a problem of how to communicate that best, and how to do that best often really depends on your context and who your audience is. Here's another good, very like currently popular one. In what does current case law suggest about all things AI and copyright? For instance, how much does a human need to be involved in order for AI generated content to be eligible for copyright protections? This is one where my answer might be different like a year from now or 2 years from now, because it's a quickly changing area of law, and there's a lot of litigation going through the courts right now. I'll start with the second part of the question, which is how much does a human need to be involved in order for AI generated content to be eligible for copyright protection? Which has seen, the US Copyright Office has seen right now. And right now, the guidance on that is that things that were simply generated by the AI and didn't have a human element of creativity in them are not eligible for copyright. They are public domain because they do not have a human author. You need to have a human author to get copyright protection. But to the extent that a human has created, has put creative effort into it, either, for example, by making a story that the AI has like generated art around, or by in the selection and arrangement of AI images. Maybe you've done something very creative in manipulating the AI images. There's a lot of different ways you can create AI generated art, some of which has more human input than others. There's a whole spectrum of things from just like inputting a phrase, probably not copyrightable because it's very minimal input, to things where you're really like tweaking the parameters and you're almost using it as a painting tool, or you're giving very creative prompts where like it's actually about, half your content and half AI generated content. The extent to which it is human creativity, that's copyrightable. And the extent to which something was just spit out of the AI is not. Where you're going to draw those lines for any given work is a very difficult fact-specific question. And you probably hope that you never have to take that to court. But you are eligible for copyright in the US, at least on any creative input that a human put into the creation of the work. As far as I know, this is the same in most jurisdictions that I know. But if you have, if anybody knows about other jurisdictions who have decided it differently, this is a great chance to chime in. But in general, this is the principle that I've seen, that the extent to which the human has created work. Other things, AI and copyright. There's litigation, particularly in the US courts right now, about whether it's permissible to train AI on copyrighted works. And that's an unsettled question right now. Currently, we believe it's likely to be considered a fair use in the same way that, for example, training on copyrighted works to make search engines or doing text and data analysis on copyrighted works would be a fair use because it's using those works as data. It's not making exact copies. It's kind of extracting data from it. And then what comes out on the other end is sort of like a mashup of that data that produces something that resembles it, but is not actually a copy. But this is something that where everybody's going to be watching in the next year or so and see like where the courts come out on that. There are some arguments that there are statutory exceptions in other jurisdictions, like text and data mining exceptions that may apply to AI training and may not. And there are some jurisdictions that are making new legislation that may address these rights more specifically and give a more definite answer. But that's another aspect that people ask about, and the answer right now is that it seems to be permissible, but this may change. And I know we've had a whole one of these webinars all about AI a few months ago, so I know there's a bunch of questions that are related to that, and if people want to ask those later in the chat, those are also welcome. So I'll move on to the next question, which is, if an open access institutional repository contains a photograph of a published book authored by an academic, linked to the record of the book, which is not available openly, would that be permitted? Like, that's I would say in general that should be okay. I'll I'll say also, I am a US lawyer. I'm licensed in the US. I know a little bit about some international considerations, mostly from our friends and affiliates, but a lot of my answers are going to be based in the US. So if you have other answers, please do chime in. But in general, something like that would often be considered to be permissible. You're using the photograph of the book as like data about the book in order to search for it. It would often be considered to be a fair use in a similar way to like a search engine. But this is also, it's not without risks. Somebody could make a claim about, for example, like reproducing the cover of the book, which probably has original artwork. I hope that somebody would lose that fight if they brought it, but it is something. But fair use is often something that does not. It's not without risk. There's always a little bit of risk that somebody may challenge it. The next one on the document is about non-commercial licenses. Can non-commercial licenses be expanded to include dollar amounts that the author fees are appropriate or dollar amounts that the author feels are appropriate or are comfortable with? For example, you can sell this work for no more than $10. So whenever you choose a CC license for your work, you can always offer additional permissions to people. So if you have a non-commercial license, you can offer commercial licenses to specific people with permission. And you can also say on top of it, like, I grant permission for any fees that are less than $10. And you'd have to make a separate statement on top of the CC license. If you're going to make that a standardized permission, we do have a protocol that gets used not that often, but can be useful, called CC Plus. And if you look for that on the CC site, you can see some examples of CC Plus being used if you want to write a standardized permission. But if you don't want to get into that, you can always just make a separate statement that offers more permissions to the public and simply say, like, I authorize any commercial uses where the amount exchanged is less than $10 or something like that. What you can't do is say, like, oh, it's CC BY, but you can't sell this for more than $10. You can't put restrictions on top of a CC license. So if you want to do something like that, you would choose the more restrictive license and then offer additional permissions on top of it. All right. The next one is, do you have suggested talking points to counter the rationale that a public institution's own archival materials that are clearly out of copyright worldwide should have a restrictive rights statement or Creative Commons license? The rationale seems to come from fear of bad actors or maintaining institutional prestige, and they include statements such as non-commercial and non-commercial use only or by NC. The legal counsel does not have time to get involved in this level of issue. This one, I think actually our open culture program probably has some, and actually, Scan, I don't know if you have good links offhand to our open culture program writing on that, because it is something that in the open culture program they've tried to counter and tried to have other ways. Mainly talking points offhand. A lot of it is. A lot of it is emphasizing that it wouldn't be these things wouldn't be enforceable in court if there is no copyright to begin with, because there is likely no copyright in the work if they are in fact just digitizing materials that are already in the public domain, clearly out of copyright worldwide, and trying and offering other solutions, such as, like, for example, they encouraging people to give attribution to them, even even if it's not through copyright. For public domain works, we do encourage people to give attribution to the sources, even if it's not as a matter of copyright. And there's a whole bunch of reasons that people are going to do this. Some is to acknowledge the institution that did the work. Some is just because you always want your users to know where you got information from. You want to, as an academic, you always want to cite your sources, or if you're a researcher or a scholar, or just anyone who wants to give credit to the work, you'd cite your sources. For example, everybody's everybody who quotes Shakespeare usually cites where that came from, even though Shakespeare is long out of copyright. Or, you'll acknowledge that the Mona Lisa is the Mona Lisa, even though that's long out of copyright. Why would you not do the same for any other works? We do encourage people to link to the official sources. If you got something from a museum or archive that did a lot of work in digitizing those works, but I'll actually ask some of our co-hosts to jump in if you have better points also.
I'm pasting some of the chat. Sorry, I'm pasting some links here in the chat. But I think that this is a very common fear that like we've heard from institutions quite often, like the bad actors doing bad things with or materials, and we don't want to do that. And unfortunately, like, well, the first thing that you need to know if someone is a bad actor, I don't think that they are going to be stopped by an CC license. Like bad actors are gonna be bad actors, and like Alamy or like some of these other websites that sell stock photos tend to also like put a lot of watermarks on public domain works, which is also a little bit on the edge of a gray area regarding copyright. And so there's nothing that you can prevent bad actors from being bad actors. But what you are doing by like putting a CC license or a more restrictive license on top of a public domain work is actually deterring the good actors that you want reusing your work, because they will definitely be stopped by whatever mark you put. And so in a way you have to counterbalance that as an argument. How much are you concerned about the bad actors doing bad things against how much are you gonna prevent good actors from doing good things with your work and your material? And so I guess that it ends up being not really a legal question, because like as Kat said, like the legal question is already solved. Like you cannot apply a CC license or write statements that does not belong to a work that is in the public domain, because legally it has no effect. The main question ends up being in the more moral/ethics area, where like how much do you actually want to prevent good people from doing good things? That's only that I would add.
Yeah. I think that's a great point too, that like that bad actors are not going to be stopped by a license from they aren't with all rights reserved material, they won't be with CC licensed material. So yeah, you can't stop people who are determined to do the wrong thing, but you can help people who are doing good things to enable their work. I'll go on to the next one in the document, which is as CC by ND allows fair use, does creating an adaptation of an ND work within this course or any course context where it's shared with course members only be in line with fair use of ND works? So fair use is always a very fact-dependent question, but in general, if you're going to use material and use a fair use justification for it, I'd say like the CC license is not relevant to your consideration. If it would be a fair use of an all rights reserved work, it would also be a fair use of a by ND work, and you don't have to adhere to the conditions of the license. Whether something is a fair use or not, like just the CC license doesn't apply. It doesn't matter what the original license of the work was if you're using it under an exception or limitation to copyright, such as fair use. So in that context where it's being shared with course members only, that could in fact be considered to be like a use that isn't even making a copy or distributing a copy. It could be considered an internal use, and that also is very fact dependent. But for example, if you're using it under an exception for like an educational or commentary exception, and you're using it in a critical context that would be fair use if it were an all rights reserved work, it would also be fair use under if it were a CC by ND work. And this is true for all of the CC licenses. There is an explicit term in all of them that says that it doesn't override exceptions or limitations to copyright. So no matter what jurisdiction you're in, if there's if there is a legislative or court-created exception to copyright, for example, being able to make adaptations for accessibility, or if you have exceptions that allow text and data mining, if you have exceptions that allow critical commentary, anything like that that would create an exception to copyright for any work, including all rights reserved, also is an exception for CC licensed works, and you don't have to adhere to the license conditions when you use a work in that way. You still might want to attribute where the work came from and the way that you're using it for all sorts of reasons, but it's not something where you have to follow the conditions of the license if it's not something where copyright applies in your jurisdiction. All right. And I'm getting to the last question that is written down in the document. So this is, I also had a quick question regarding NC. In my university, business students are recruited by actual businesses to do research for them for their senior capstone. Are these students allowed to use NC licensed materials in their projects? My first thought was no, because they are conducting research that will inform decisions and not necessarily the reproduction of the licensed material for profit. I would say in this case, like NC is also very fact specific in how it's used. It does depend on the use and not the user, but if the work is going to be put to a use that is directed toward like economic advantage, either making money or like improving somebody's business position, the conservative opinion would be to say like, no, that you can't use that material for that. You'd need to you get permission from the author. So if something is being used like as an actual product for an actual business that they're actually going to use in commerce, I would say in general, like not to use NC licensed material for that. Either that or to get permission from the author. If it is something that really is only going to be research and maybe used internally, maybe not directly commercial, there's a stronger argument that that would not be considered a commercial use. But in general, if something's going to be used for an actual business to help further their economic position, I would be conservative and only use material that's available to be used commercially for that. Except in situations where you'd also be able to use all rights reserved material. Again, thinking like you'd be able to use NC material in the same way that you'd be able to use all rights reserved material. So for example, if you were going to use NC licensed material simply as research and you weren't actually going to copy any of it, you could do that for anything, like any book or material that you found you could use for research and simply take what you've learned from it and apply that to other work. But you couldn't make a copy of it and distribute that in a product that you were going to use for business. You couldn't do it with all rights reserved work, so you probably also couldn't do it with NC licensed work. But this is a case where it's going to be very fact specific. It's often advice I often like to give people is do something that you would not have a hard time explaining to either the author of the work or a judge, because those are the people that you ultimately are going to have to convince. But yeah, there's if you can use material that is available for commercial use for these projects, that's generally the best way to go. All right. And I am out of questions on the document now, so here's a great time to jump in and raise your hand. It doesn't matter if it was on the document or something that might have been raised by a previous question. The floor is open.
I have a question about using no derivative items in a course. So let's say that the course package uses multiple open ed resources and it doesn't make any changes to the no derivative materials. It's just putting them into the course as the author created them. But some of the other areas in the course might have a derivative of 3 other textbooks that aren't ND licensed. Would that act more as like a collection since the ND ones weren't edited?
Yeah, that's right. When you're distributing a collection of works, you're really just like distributing like basically you're distributing the individual works like as a collection, like in a package, and what you do to one work doesn't affect like what you're doing with the other work. So you're not making a derivative of the ND work, you're just distributing alongside something that you were permitted to make derivatives of.
Okay, so I would just need to give the correct attribution for the indie work and then where the item, the remixed pieces are clearly identified that those were the pieces that were remixed. Okay, thank you.
Yeah, and it's also the case that like you can make changes to an ND work that aren't considered derivatives under copyright law. A lot of people ask about excerpting, like am I allowed to take an excerpt of a large work that's ND? And that's generally permitted because it is not considered to be making a derivative or an adaptation under copyright law. You're not changing the work, you're not adapting it, you're simply taking a small piece unchanged, and that's often permitted as well. So for example, if you have an ND book and you only want to reproduce a chapter, like that's permitted. In other sessions, we've often had a lot of questions about what exactly is a derivative, and that's another one of these things where you can just go down a rabbit hole forever because it's very fact specific. But often like it has to be something that like incorporates some of the original work along with your own creative work to make something that's new and incorporates creative work from both the original work and the new author. But often things like if you're just a lot of people ask questions about like, can I copy edit this or can I like reformat it so it fits on our pages, or like, can I take an excerpt? And those are generally not considered to be making derivatives. But if you're going to like say rewrite something to update it to like current practice, or you're going to mix it with new material, that usually is. But where exactly that line is something that's you know, that a lawyer can give you advice on, but often like is it or not is a very difficult question to answer.
And I have a kind of a separate question, although if folks have questions about derivatives, this is a good time because that is super confusing. One of the questions I get often is I create something on Canva, which is a for-profit platform, I think, or I'm not sure what it's considered, but they create their own images and formats and whatever, and they have their own license. Can I license my thing that I created with the Creative Commons license, or am I limited by their terms of use in some way?
Yeah, in that case, you should look at their terms of use to see like what you're permitted to license and like what they've given you permission for. Any work that is your own creative work, such as like text you've added or like images you've added or the specific arrangement, should be something that you can put a Creative Commons license on. But if there are elements of it that they insist that are under their proprietary license, I seem to recall that Canva like has their own license on, for example, some of the design elements and things like that. Like that's something that you'd have to acknowledge as being under their license. You couldn't CC license that because that's their intellectual property and they control the rights to that. But your own text and like your own, you know, your own images and any creative work that you put in, you can license however you want.
And actually, I have another question. If no one else is going to ask, I always have a plethora of questions. This actually came up in the last OE Global conference, and it has to do with derivatives. So I'm going to put a link in the chat, and I'm sorry if this is not a great way to do that. But the question kind of came up. The image there is made of, I think, 5 or 6 things with different licenses. And they're cropped and kind of placed together. It's more like a collage than anything else. And kind of getting back to your question about what rises to derivative. Is this a collection or is it a derivative? Thoughts?
Trying to open this link here. My laptop does not want to open this link right now.
And maybe I can explain it. It's more or less a collage. So there's things placed together, maybe cropped a little bit, but not adapted individually. However, the way they're placed creates a larger picture that's different from from what the original intended, I think.
Yeah. So again, this is a very like, oh, it's because it wants my Firefox to restart, which I am not going to do right now while I'm on this call, but I will just go from your description of it. It's always great how this comes up like in the middle of calls. But I would say like when you're doing something and like you've taken creative works, even if you haven't like made a change to a work directly, but you've incorporated it into a greater whole in such a way that like that it's that would probably be considered to be creating an adaptation, but it really would be fact specific. Like you're clearly intending it to be part of a greater artistic work rather than here are these 7 things and I'm distributing these individual 7 things to you, the way it might be in a course pack where you have 7 readings or something like that. Rather like here's a giant picture that is made up of all these other individual elements.
Thank you.
All right, I think that we can do a last call for questions. See if anyone has another question, and if not, like you can have a few more minutes back from your time.
This may just mean that in the last session Meredith answered them all so well that I don't have anything left to answer.
All right. So thanks again, Kat, for your time and for everyone for being here. This recording is going to be shared afterwards in the Slack channel. So if you want to go back to some of the questions that Kat replied, please do so. And also, I think that you are there in the Slack channel as well. So if there are any follow-up questions that you want to ask to Kat, you can also tag her along or tag the facilitators and they'll tag Kat if she's the one that needs to intervene there. So thanks everyone, and thanks Kat in particular for answering all the questions.
Thank you. It was lovely to be here, and I hope you have a great rest of your program.